Yes, sir. Good afternoon, everyone. My name is Neil Kamal, Senior VP NIA, and the topic is role of victim in investigation. As we are already short of time, so I will try to complete all this thing within with limited periods. So, first of all, the victim definition of victim introduced in the CRPC in year 2008 by Amendment Act, and it's a very recent origin. And after 14, 15, 16 years, as our focus is on victimology, so we have to widen the definition of victim. As a victim, as per definition of victim, uh, against whom an act or omission committed. But I want to suggest that it should be widened to include should be society. If offense is committed against the society at large, then this can also be included in the definition of victim.
Slide चला दीजिए.
Further, by UN Declaration 1985, certain rights of the victim were recognized. These are right with respect to self-respect, to be present in all proceeding, right to rational protection, right to information during investigation trial, right to compensation. Now, victim role in investigations starts right from the stage of registration of FIR. If the copy of the FIR is not provided to the informant or the victim, he can approach the superintendent of police. He can write to him, and if even SP denies, then the victim can consult, made an application to the court who is competent to take cognizance of the offense, and the magistrate can also order investigation into offense as per section 156 clause 3 CRPC. So he has a right to free copy of FIR and other documents like challan, witness statements, and all other oral and and the victim should have the knowledge about that fact. Now Tariq has gone into abyss. Now zero FIR has been institutionalized. Now there is a provision for EFIR, and now with the introduction of new laws, a case cannot, if a prosecutor want to withdraw a case, then the victim has a say in that matter. So victim consent is also required, and forensic evidence is made mandatory in case of which are punishable with 7 years or more imprisonment, and rape victims can give statements recorded in their mobile in the presence of family members. Property of proclaimed offenders can be attached even during even outside India. Like this is the proclamation is made during investigation. That's why I am saying, reading all these provisions. It has been made compulsory to give response to victims after they lodge a complaint to provide them information within 90 days. Also about the progress of the trial fortnightly by SMS or other modes of electronic communication. So, finally, in suggestions, like a list of advocates who can assist support the victim must be properly maintained at police stations. For sexual offences, right of a victim to have his or her statement recorded at their residence must be strictly adhered to. Police must give assistance on-site crisis intervention. All the police procedures, court procedure must be explained to the victim by the IO, holding officer, PARV officer, or the PP concerned. If the victim is not by knowing about his rights or the procedure, how can he enforce those rights? Victim should protect the evidence during investigation, like if there is any clothes or other samples, they should be protected from this. Victim should play a active role in identification of offenders. Further, under new laws during bail, appeal, victim got the right to be heard in the court during court proceedings. And lastly, if a translator is required, then it may be timely intimated by the victim to the IO or the PARV officers concerned. Thank you.
Thank you so much, sir. Now I will request Satyanarayan sir to please